Great to have you here. Now, 3 justices of the High Court removed recently by President Akufo-Addo have vowed to challenge the decision they describe as disappointing. The president removed Justice Akufo-Addo, Justice Atapol Derry and Justice Mustafa Habib Logo from office as justices of the High Court by a letter dated Thursday, December 6, 2018. This was after the committee established by the Chief Justice, Justice Sophia Kufu, pursuant to Article 1464 of the Constitution, to investigate a complaint lodged against the 3 judges by Anas Aremeyaw. Anas recommended their removal from office. According to the presidency, the committee concluded that the conduct of the justice amounted to a criminal offence under the Criminal Offences Act 1960 Act 29 as amended. President Akufo-Addo has thus directed that a copy of the committee's report be submitted to the Criminal Investigations Department of the Ghana Police Service for the requisite actions to be taken. JoyNews' judicial correspondent Joseph Akable joins me in studio. And Joseph, briefly a background to this incident. It's been quite a while.
Yes, these 3 judges are among a number of judges who were caught in the Anas famous judiciary corruption documentary. And now these judges were captured in various acts, receiving monies from individuals who we later found out to be working for Anas's company Tiger IPI to influence their decisions in court. Justice Derry, you recall, was one famous character in this particular video due to he receiving a goods in that particular documentary that was widely publicized. So the judges have for some time now been fighting the matter in various courts because Anas had petitioned the Judicial Council asking that they be removed. Now, they took the case to the Supreme Court challenging the capacity of Anas to file that petition because they say his company, Tiger IPI, was not a registered company. Now, the Supreme Court did admit that the company was not registered at that point, but it went ahead to say that the petition was valid nonetheless. So they are currently in the external court saying that the Supreme Court, by admitting that the petitioner was not validly registered, erred and violated our human rights by proceeding to hear the substantive disciplinary case against them.
Joseph, I'll just have you hold on briefly because we've got lawyer of the 3 judges, JoyNews, on the line. Good morning to have you here, sir.
Hi, good morning. And how are you?
Great. My colleague Joseph Akable is just giving us a brief background to this story. I'll come and take your reactions briefly because we've heard that you've hinted of filing an additional case. I'll come to you shortly. But Joseph, so right from there, where did we go with this case? So
since then, the matter has been going on at the external courts. Since this particular notice came from the presidency, we have checked with the Attorney General's department. The question that we posed was why there's a pending external matter, yet they proceeded to dismiss the judges. And the response we got was that it was due to a decision that came from the court. Now, this was an application that was filed by lawyer Addo, who is currently on the line with us. They had filed for provisional measure. Now, they had made that application because they had realized that the government had taken 3 administrative steps, including requesting them to appear before a disciplinary committee, despite a 25th May 2018 order of the ECOWAS court urging the government to suspend further action on the matter until a ruling on the motion. So that was the application they made, and the decision of the panel was that they could not establish the grounds for the urgency or irreparable loss that could be suffered by the applicants, that is the 3 justices, if the motion was denied. So the AG's office tells us that it was because of this decision that's coming from the court. That is why they proceeded to announce the dismissal of the judges.
And let's now get reactions of lawyer JoyNews. And great to have you here, sir, once again. Now, you've hinted of filing an additional case. Why?
Oh, it's very simple. And Joseph, I'll just give you the background. Now, in somewhere, I think in May, thereabout, we had, when we were before the ECOWAS court, we had filed for interim measures. There was a different panel, you understand, who was handling that case at the time. They gave an oral injunction, which was restraining the government, the Chief Justice and the Chief Justice's committee from proceeding against my client. Now, when the substantive motion was to be heard, the tenure of office of the dead judges had expired, so the new set of judges were sworn in, and they took over the matter. So this new set of judges heard the interim measures application for the first time in November. They decided that, look, we had a prima facie case, but then the court, if you read the rulings, then the court had the, if at the time we had even filed the case, our clients had been removed from office, the court had the power to reinstate them. So let's proceed with a substantive matter. And so they denied our interim measures application and said, we should proceed with the substantive matter.
Exactly.
Which also meant that, yes, it did not measure proceed. Now, the question you ask yourself is, between the 25th or 28th of November that we went to the court and the 5th of December, the committee should produce one single letter from it, inviting my clients to appear before it and to have their case heard. You understand? So, clearly, this decision had already been taken in respect of the report. I mean, you can't blame the president because the president must act once he receives the report from the Chief Justice's committee. So the president had nothing to do in respect of this matter. But the question to be asked is, were my clients given an opportunity to be heard by this committee before a decision was taken that they were guilty of anything? No. And so they have decided that even though this case is pending, you know, and we have this matter pending in respect of their breach of their right to privacy and others, which is going to be heard on the 23rd of January. Now that an action has been taken to remove them from office, they will proceed back to the court and add an additional matter that they were not heard before they were removed. Okay. And so this also adds an additional chapter to the case.
So this additional case you talk of, which court are you heading to exactly?
We are still at the ECOWAS court.
Okay. If I get you right, you are not, so to say, upset by the decision to have your clients dismissed, but you are questioning the processes.
We are. You can't be upset at the president because the president is bound to act upon the recommendations that you receive.
What I'm saying is that is it the processes you are not satisfied with?
No, but the point is this: if you say you are guilty of something and you've gone to court, the court says, "I'm going to hear the substantive matter on the 23rd. Nevertheless, I will not grant your application for interim measures to restrain the other party. The other party can proceed with the disciplinary matter." The question is, wouldn't fairness demand that you now write to me and say, based upon this decision, come and appear before the committee and have us investigate whilst we go ahead with the substantive matter? You have two choices. You can wait for the substantive decision, or you can decide that despite the fact that the substantive decision is ongoing, let us go ahead, but then, of course, let us invite them to be heard. Now, the question is, between the time of November 24th or 25th, where the decision was taken, and now, they should produce one letter that invited the judges to appear before the committee. None, which presupposes that the report had already been prepared.
Okay, now, so you're telling us that you're going to court, that the substantive matter will be heard on the 23rd. So,
yes.
so you've told us. So
yes.
the case will progress. But tell us, how are your clients doing?
Oh, they're doing fine. I mean, they are disappointed. Yes, I mean, it's Christmas. You would expect that the season would come with good news. But hey, I mean, they fought this thing from 2015, and so. You can imagine that, yes, they have been dragged through the mud, and, you know. But all they are demanding is that at the end of the day, there must be some fairness in the system. You understand? You may remove them, but if you do it within the ambit of the law, nobody will have an issue with you. But when you violate their rights, they will ventilate their rights.
Okay. Now, finally, you mentioned earlier that the ECOWAS court has the power, after hearing the substantive matter, to reinstate these judges. Yes, we've seen that. If they deem so. So, question is, why are you filing an additional case based on this dismissal?
Yes, because there are two legs of the case. The first, the ongoing case has to do with the breach of their right to privacy. You understand? The evidence having been obtained illegally. The issue of the house light, the matters that are before the court now are distinct from the current situation that has happened since yesterday. Now, the president has removed them based on the recommendations of the Chief Justice Committee. They are saying that they have never been invited to appear before any committee after the ruling of the court. You understand? They had an interim injunction which was granted. Now it was lifted. At the end of the day, if you say that you were to proceed with the agency department say that they were now empowered to proceed with the disciplinary proceedings, and the question is, where is the letter of invitation? Between the time that the ruling was done and now, they should produce one letter that has invited the judges before the committee. None.
Thank you very much for your time this morning. Ni Bakbo Samoa is Akufo-Addo is a lawyer for the 3 judges, High Court judges, who were dismissed or who have been dismissed by President Akufo-Addo. So briefly, apart from mentioning why they decided to take this action, I'm talking about the Attorney General's Department, what else have they been saying about this case moving forward?
They made a point that as far as they are concerned, they'll continue to respect the external courts, and that is why they make representation in those courts anytime a Ghanaian citizen takes the matter up. So in their own understanding of the law, they follow the due process and they dismiss the judges accordingly.
Thank you very much. Judicial correspondent there, Joseph Akable, bringing us details of what the Attorney General's Department has been saying about the dismissal of these 3 High Court judges. We'll keep our eyes on the case in these international courts. I'm talking about the ECOWAS Court and the African Court for Human Rights, and bring you updates when they are available.